Good afternoon, it's the Rains Feldman Cyber Liability Gang with our latest update. I'm Eric Syverson with Steve Gebelin and Scott Lesowitz, and today we want to talk to you about an interesting case that is part cyber law and part contract law. And this case involves a local Los Angeles, a local TV personality called Kurt Knudsen, who styled himself as the cyber guy, and he did local TV spots relating to internet and technology. And so the question, and he was on the local Channel 5 here at KTLA. He left KTLA, and then the question came up, can KTLA keep using his content, and in what manner can they keep using it? So I'll throw the ball up in the air. Steve, why don't you tell us the basic facts as you recall? I mean, I sort of already laid it out, but is there anything I left out, anything we need to know more specifically?
Well, Knudsen was entered into a contract with KTLA that let them and their affiliate network through the Tribune news industry redistribute his pieces that he was putting together for the cyber guy. It had certain requirements about how they had to promote them or advertise them, and gave them rights in perpetuity to use anything that he created for them.
It would be a work for hire situation as far as copyright is concerned, right?
Yeah, along the lines of work for hire for copyright. It was a period of years that for the contract. After 3 years, the TV station had a chance to terminate the contract. They did. He brought this lawsuit against the local station and then its affiliate network, saying against the local station, some other employment-related claims that aren't really at issue in this appellate case we're worried about, but against the content network, saying on these other websites that are owned or operated by the other networks that you guys give content to all over the country, you guys are still using my content, you're still using my name, you're still using my pictures in connection with this content, and that's a violation of my rights of publicity here in California. So that's the claim that he brought, and that's the claim that was analyzed by the California Court of Appeals. In actually sort of an unusual procedural posture. The TV networks brought a summary judgment claim or motion that was denied, and they filed a writ for appellate review of that before trial. Usually those don't get granted, but in this case, not only was it granted, but they ruled in favor of the TV networks.
Interesting. So the cyber guy did not prevail. Do you have any thoughts, Scott? So, I mean, the case is really a breach of a license agreement type of case. Is that how you see it?
Yeah, largely it's a breach of contract case because normally you can't just use somebody's content or likeness without his permission. One of the big issues here was whether or not using his image and name on the webpage the way it was, whether that constituted an advertisement or an endorsement. Because under the contract, there were more limitations on endorsements than there were on advertising the content. And so one thing that the court analyzed was whether or not you could construe his name and likeness as being an endorsement for the networks as opposed to just advertising the content.
I'm assuming the court said, well, I mean, they signed up for this content, they're just referring to the content. The guy's the cyber guy. It's not an endorsement of the quality of the content. It's just calling an apple an apple or a rose a rose. Okay. So what is the lesson, I suppose, that our very, very few viewers can draw from this? What should people wanting to acquire this type of digital content pay attention to? I guess this case is helpful in my mind for people who want to purchase digital content and distribute it across affiliate type of networks. Anything else we should know?
Yeah, so this case gives you a good example of what your contract should do for you when you're buying this kind of content. you should make sure you're getting publicity rights from the person that's involved in the content to allow you to advertise the content that you're buying. Otherwise, down the line, if you have some sort of dispute, this kind of claim can crop up, and in exactly this situation, Knudsen had wanted to bring other claims, and he tried to use this as sort of an extra front to fight the TV networks. So by making sure they had locked down the ability to use his name and likeness to advertise the content, they were able to get out of these claims.
Scott, it seems like if you're Knudsen, the silver lining in this for future Knudsens, for future cyber guys, maybe that, I guess that, although it doesn't seem like a great claim, it's a way to get around copyright, maybe, the preemption issue. Was there a copyright preemption issue? I mean, it strikes me that this is kind of a creative way to bring a copyright type of claim, or is that wrong? I mean, were there any preemption issues here?
No, there weren't any there were not any that were brought up in the court's decision.
And the agreement was pretty clear that he transferred all rights in the content itself to the networks. So,
but I guess what I'm getting at is, even though you do that, I guess maybe it isn't a silver lining, but I guess there's no ruling here that it's just a copyright claim dressed up as a right of publicity type of claim, I guess is what I'm getting at.
Yeah, no, the court didn't at all go down that line, and I mean, there's this, it clearly treating the right of publicity claim as something different than a copyright claim, even though the rights of publicity are his image that are part of the content that he's are within the images and the content that got transferred over. So yeah.
And I guess a final point that I'd like to make, I guess, this went away on summary judgment, correct?
Well, in the end.
In the end. Yes. So
I guess what I'm getting at is, from a pleading perspective, it didn't go away upon demur. It's just that this guy, on these facts, didn't have enough evidence. The contract precluded him from succeeding.
Correct, although I would say that, on this appellate court very well may have disagreed about whether the pleading was good or not. I mean, the appellate court hears the facts at the point that it's brought and the posture in which it's brought.
Right.
So, I mean, if the contract were, attached to the complaint, and the, how it was used attached to the complaint, and which, I mean, if you're referring to the contract in the complaint, even if you want to be cute and not include the contract, it's part of the, it can
Right.
be part of the complaint. So very well, it could have been demurred now. I mean, this type of case might be demurred in the future. And I think the silver line to people like Kurt the Cyber Guy is that if the contract were written differently, he would have won.
So pay attention to the details when acquiring content, both over-the-air broadcasts and digital distribution. That's it for our cyber liability update today. The cyber liability update was about Kurt Knudsen, the cyber guy. So we hope our 10 or so viewers enjoy this update. I hope we have a little more viewership than that, but not much.